Hello viewers, students and friends. This is Dr. Kashinath Neharkar, Assistant Professor Sri Shivaji Law College, Parbhani, and I welcome you in my YouTube channel Law Education Volunteer Dr. Kashinath Neharkar. Friends, in this lecture we are going to discuss very important concept under Transfer of Property Act, and that is rule against perpetuity under section 14 of the act. But friends, before that, please subscribe this channel and press bell icon to receive further notification. So friends, let's start with today's lecture. Friends, as you know, we have already discussed in previous lectures that transfer of property is nothing but a transaction between two or more living persons to transfer property voluntarily. Parties are called as a transferor and transferee. These two persons involved in such a transaction voluntarily, and the effect of that transaction is that the property of transferor goes to transferee absolutely. So as soon as the transaction is completed and as soon as the transferor gets the consideration for that transfer, then his all rights in that property are extinguished as soon as it goes to transferee, and then transferee becomes absolute owner of that property. He can enjoy that property absolutely, he can transfer, he can prevent, what the different kinds of rights that are available to him under the name of property right that he can exercise. It means he becomes absolute owner of that property subject to the power of government. So this is what the effect of that transaction. See, while discussing section 5, we have discussed some essentials of section 5, and the one of essential is that there must be two living persons. So transaction between living person is regulated or dealt by section 5. Therefore the property can be transferred to living person or the person who is in existence at the time of transfer. Therefore a property cannot be transferred to the person who is not in existence at the time of transfer. But section 13 of the act provides a mechanism or the process which provides transfer of property for the benefit of unborn person. So the person who is not in existence at the date of transfer can be ultimate transferee as per section 13. So as per that section, prior life interest shall be created in favor of the living person who will get limited life interest. And when ultimate beneficiary, when unborn person comes into existence, the property will be absolutely transferred to transferee. So therefore as per section 13, property must be absolutely given to transferee. He cannot get the life interest or limited interest property. So this is a provision that is provided by section 13, and this is provided for the benefit of unborn person. So as per section 13, the unborn person must be absolute owner of that property. And see, section 13 and section 14, these are closely connected with each other. So as per section 13, the transferor cannot transfer property to unborn person directly, but he has to create prior life interest in favor of that person who is preceding to unborn person or who is before the unborn person. And as soon as the unborn person comes into existence, it is the responsibility of the person who is holding that property in a trust to deliver it to unborn person. But section 14 provides what is the extent to which the vesting of property in unborn person can be postponed. Whether that unborn person shall get property as soon as he takes the birth, or whether any other provision can be provided by the transferor. See, section 14 is very important. Actually, it is a right of transferor to dispose the property as per his will and wish, but he shall not cause any self-destruct by transferring such property. That is the reason why the vesting of property in favor of unborn person can be postponed, but that should be postponed only up to that period which is provided by section 14 and not beyond that. And even if such a transaction is made which provides for the postponement of vesting of interest in unborn person, or which provides for the consecutive life interest, limited interest in several number of unborn person, such will be void beyond that limit, and such will be valid only up to the extent which is provided by section 14. Let me see it is in a specific manner. See, firstly we must understand what is the concept of perpetuity. So friends, though this lecture may be lengthy lecture, but please concentrate on what I am telling you. Say, firstly we must understand what is perpetuity in general, and accordingly perpetuity is nothing but indefinite period, permanent period. Perpetuity means in general we can use the word perpetuity in regard to injunctions, temporary injunctions and permanent injunction. Perpetual injunctions means the permanent injunction. Similarly here the perpetuity is, we are taking some different meaning, though it is a permanent, but different meaning is that for indefinite period. Permanent means indefinite. We cannot say that this is valid for 2 year, 4 year, 5 year, 100 year, nothing. So therefore you should take the meaning of that word to that extent. Then see, if you take this word in context of property or the transfer of property, perpetuity means making property inalienable permanently. See, you must understand the consequence of this word, making property inalienable permanently, and this is done by act of transferor. Transferor making his property inalienable. How? See, it is his will and wish. That can be, but law doesn't allow such things. Law doesn't allow self-destruction of property. So we see how it is. See, it is a transfer in a permanent way by making property inalienable for indefinite period or forever, because this is not in the interest of property. See, property must be alienable at any time. The person who is owner, he must be free to alienate that property as per his will and wish. And if there are any restrictions on owner's right to alienate that property, then it will not be helpful for owner as well as property. Therefore this is against the interest of society, public order, property itself, and such acts are prohibited by section 14. Therefore it is a rule against perpetuity, or it is also called as prohibition of transfer of property in perpetuity. You can see how a person can transfer his property in a perpetuity. We can see here, where a property is transferred in such a way that it become non-transferable in a future for indefinite period. Such a property is tied up with transferor or his family from generation to generation, and such a transfer is called as a transfer in perpetuity. See, you know what is the nature of human being. His selfishness is not hidden from public, everybody is selfish, and some property may be very dear to some person, and he may not want to lose his property from generation to generation. So after his death also he wants that property should be stick up with his family only, and his further family members, his descendants, shall not sell it to another other person. And in such fear he transfers such property in such a way that his descendants are disabled from selling that property, and such transfer by transferor is called as a transfer in perpetuity. See, and this can be done by two ways. One is by taking away transferee's right to transfer. By taking away transferee's right to transfer. So when by a particular single document, for example transferor is A, he transfers his property to his descendants that may come in existence in a future in such a way by giving them a limited interest. That can be a transfer in perpetuity. For example, A transfers the property to B, who is living at the time of transfer, for his life, then B's eldest son for his life, then B's eldest son's son, and the further continues, and every person who is going to come in that chain, he gets limited interest, and such transfer can be called as a transfer in perpetuity. And second is by creating future remote interest in favor of transferor. So how that property shall be dealt by the descendants even after the death of transfer, if it is provided by single document created by that transferor, his directions in that document can work as a remote in his hand for future dealings of property, and this is also the transfer in a perpetuity. If you have any doubt after lecture, you can mention it in the comments. See, now we are going to see what is section 14 specifically that provides. What is a rule against perpetuity? What is the prohibition of transfer of property in a perpetuity? Firstly, you must see, understand that section 14 firstly provides, allows postponement of vesting of property in favor of unborn person. It means this is also the transfer in perpetuity, but not in perpetuity for particular period. And secondly, section 14 prohibits transfer in a perpetuity beyond the limit that is provided by section. Afterwards you can find where the limit is provided. See, firstly just go through the bare section. Rule against perpetuity: no transfer of property can operate to create an interest which is to take effect after the lifetime of one or more person living at the date of transfer. In short, such persons can be called as the persons holding prior life interest, and the minority of some person who shall be in existence at the expiration of that period, and to whom he attains full age, the interest created is to belong. See, this is the period which is provided. Let me see what the explanation of section 14. If you have any confusion, that can be taken away. See, firstly we must see some important information relating to section 14. Firstly, friends, section 14 prohibits transfer of property in a perpetuity. Section 13 provides transfer of property in favor of unborn person. Similarly, section 14 of the Act allows transfer of such property to unborn person. But the vesting of property in unborn person, the postponement of vesting of property in unborn person, that is specifically provided by section 14. Then it prohibits the transfer of property by making it alienable, non-transferable in the future. This is what the perpetuity prohibited. The transferor cannot take away transferee's right to dispose or transfer the property. By this section, the effect of basic object of this section 14 is Section 14 allows non-transferability of property only up to the limited period which is provided by Section 14. And Section 14 is exception to Section 10, which provides that any condition on a restraining transferee's power to alienate is void. To some extent, it works as an exception. So there are some objects for which Section 14 is provided. See, first object is to respect transferor's right to transfer of his property up to certain limit. Okay, if you want to give his property to unborn person by creating prior life interest, it should be respected, but that should not be allowed in such a way by which he can make his property inalienable for indefinite period or for forever. So both the things, and therefore second object is to prohibit making property non-transferable for indefinite period. This is second object. Then third is to ensure free and active circulation of property in the interest of trade, commerce, society, betterment of property itself. See, because if such a property is tied with particular generation, then other persons who are capable to purchase the property or who want to use that property for better purpose, they may not be able to purchase because of such a transfer or such inalienability. So that is in the interest of trade, commerce, etc. Today we see what you can convert your agricultural lands into non-agricultural land, you can sell it for other person, other people can purchase land for construction of house, buildings, industry, etc. So the properties are necessary, therefore free circulation of property is necessary, whatsoever the kind of that properties, it's free circulation. The person who want to sell that person must be capable to sell, and the person who want to purchase, with certain exception, he must be capable to purchase. So that is in the interest of society, trade, commerce. So because non-transferable properties are of no use for anybody, even for the owner, for society, for public, government, etc. Therefore, and if such a kinds because even if that person faces any difficulty, any urgency, he may not be capable to transfer. Even if that person has to undergo any treatment of severe diseases, incurable diseases, even in such circumstances that person may not be capable to transfer. So it is of no use for owner, even the society also. And if such transfers are allowed, then what will be the result? What is the need of Section 14? If such transfers are allowed, or in the absence of rule under Section 14, one day what may happen? All the properties on earth may get tied with a particular generation or particular family from generation to generation, and other persons may permanently deprived of getting access to property, because getting access to property, land, natural sources, this is also one of the basic right of everybody. This is necessary for the development of everybody. So that will happen. Now let me go through the essentials of Section 14. Because Section 14 prohibits the transfer of property in perpetual manner by making it inalienable forever. So first essential of Section 14 is that there must be a transfer of property. There is a transaction between A, the person the owner causes the transfer of property. Secondly, that transfer is made for the benefit of ultimate beneficiaries who get the absolute interest. This essential may be satisfied or may not be satisfied, but generally there can be such transaction. In certain circumstances, the transferor may create several prior life interests in favor of so many unborn persons. For example, A is a person, B is his son, then B may have son in the form of C, then C may have son in the form of D, it can go up to Z. So A can make such a consecutive life interest in favor of A, B, C, D, E, F, Z. Okay. So such can be the transaction. Then third is ultimate beneficiary must come under existence before the death of last preceding living person. See, as section 13 of the act provides that prior life interest can be created in favor of only those persons who are living at the date of transfer. So prior life interest cannot be created in favor of unborn person. This is basic rule you must understand. Then the vesting of interest. The vesting of interest in favor of ultimate beneficiary may be postponed only up to the life or life of person holding prior life interest plus minority of that ultimate beneficiary and not beyond. This is the crux point of section 14. Section 13 does not provides when ultimate beneficiary shall get his property. It is not clear about whether that person shall get the property as soon as he take the birth or he has to wait for some more period, because section 13 provides that the property can be transferred for the benefit of unborn person, and it should be transferred only through by creation of mechanism which is provided by section, that is transfer by a prior life interest. But section 14 provides that if there is a desire of transferor to postpone the vesting of interest in favor of ultimate beneficiary unborn person, okay, it should be respected and it can be allowed, but that period is only up to the maximum period is only up to the minority of that person, minority of ultimate beneficiary. It means as soon as the unborn person comes into existence, he is entitled to get that property, and but for that purpose he has to fulfill the condition, and that condition is that he has to complete the minority period. So this is the section 14. So the maximum remoteness of interest, so maximum remote in favor of transferor can be created only to that period, and that period is minority of the ultimate beneficiary. Then the maximum period in case of ultimate beneficiary in a mother's womb, because mother, the person who is in mother womb, he is also considered as a competent transferee. Therefore that period in which that person lives in a mother womb, then his lifetime plus next person who is ultimate beneficiary unborn person, his minority period, that will be considered as a maximum period to which the vesting of interest, vesting of property can be postponed. So where the ultimate beneficiary is in the womb of mother, maximum period is up to his minority again. So the nature of interest which is provided to that person may be the contingent interest, and he must fulfill the condition that he must attain the age of majority. It means he must complete the age of majority. Then this is called as a contingent interest. So this is section 14. It means the vesting of interest in favor of ultimate beneficiary can be postponed only up to the period of his minority and not beyond it. So even if any transaction provides for that, then that also can be invalid. For that there are certain exceptions. This rule is rule against perpetuity. It means it does not allow transfer of property by making it inalienable for indefinite period, but there are certain exceptions. First is the transfer of property for the benefit of public at large. Yes, the trust can be created. So the trust properties are always inalienable, because such property or the usufructs or the fruits of that property should be used for the beneficiaries, and the trust shall trust is the person, artificial person, and it continues from generation to generation. So if that trust is made for charitable purposes like knowledge, commerce, health, education, beneficial to mankind, such transfers are not valid. So creation of trust of property is not invalid, and section 14 is not applicable to such a trust. Then next is personal agreement. See, section 14 is applicable to those transactions which transfers property from one person to another person. Therefore it is not applicable to the personal agreements. Personal agreements, if somebody is appointed to do some things for the owner, as per that agreement, then it is not called as a transfer of property. So this is the personal agreement. So where the transaction creates new title in favor of transferee or no, if it doesn't creates new title in favor of transferring that property, it is not the transfer transaction. Therefore to such a transaction section 14 is not applicable. Then it is not applicable to vested interest, as you know. Then it is not applicable to provisions for payment of debts of transferor at the date of transfer. Say, but obvious, when a person is making gift of his property to somebody, and if his gift is onerous, so if that person accepts onerous gift, then he has to accept was the liability of transferor. And at the time of accepting that gift, if that transferor has borrowed some debts, then it is responsibility of transferee or the person who gets such a gift of property to pay it. So this is the exception to which section 14 is not applicable. It is responsibility of transferee to pay the debts of that transferor. It means he has to pay the amount of creditors of transferor. Then it is not applicable to the covenant of redemption of mortgage, because as you know, once mortgage is always mortgage. It cannot be changed unless specific agreement is there. Then it does not apply to transfer to class. It is similar like the trust. Therefore it is also not applicable. Section 14 is not applicable here. It does not apply to preservation and maintenance of property. Some transaction can be made, agreement can be done, by which the transferee is made obliged to raise the income out of that property and to take necessary repairs to maintain that property. Such agreement is made. Again, section 14 is not applicable. Even it runs beyond the time limit that is provided by section 14, and it does not apply to salary, areas of salary, etc. So friends, this is the concept of rule against perpetuity. Let me understand this concept by pictorial form. This is very interesting. Just continue you. This is very interesting. See, this is property, and this property belongs to A. And what happens, A makes a document. You can see the document on display, and through that document A transfer such a property to Z, who is ultimate beneficiary, unborn person, through prior life interest in favor of B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, Q, R, S, T, U, V, W, X, Y. Okay, so he makes such transaction. The question is whether a particular person can make a gift of his property in such a way. Yes. See, it is his desire, it is his act. Its validity or legality or illegality will be decided by the parties. It will be decided by the court when it is going to be challenged in a court, but he can make so. So as you know, the act came into existence in 1882, and before that such transactions were not new to society. So he is the owner of that property, and he makes a document, and by that document he transfers such property to unborn person, who is Z, in favor of Z, through prior life interest, successive prior life interest in the name of B, C, D, etc. Let me see. See, he executes a document, and to that document A is a transferor. See, and he makes such a gift deed, and by that gift deed he creates prior life interest in favor of B for his life, then for C, then for D, then for E, then for F, then for X, Y, Z, etc. And Z is ultimate benefit. Maybe, may not be. So such transaction is done. It means he makes such gift deed, he signs it in. Then the question is, what will be the validity? What will be the validity? See, here the person who are in existence at the time of transfer are A and B. As per section 13, such transaction is valid only up to C. because he can transfer property in favor of unborn person C by creating prior life interest in favor of B. But the nature of transaction here is somewhat different. So what will be its legality? And for making such transaction legal, section 14 helps us. So with the application of section 14, so application section 14 comes to help to decide the legality of such transaction. And once it is made applicable, see what is the result of it. See, the age transfer in favor of B, it is valid because it is prior life interest. Age transfer in favor of C, it is valid, and with the application of section 14, C becomes absolute owner of that property, and with that the property cannot be, with the application of section 14, what the transfer which is made in favor of further persons, right, from D to Z, it is not valid, it cannot be enforceable. So now the vesting, we must understand another important point we must understand is here the A has created a remote in his property, how it will be regulated, and according to his will the property shall go to B, then C, then D, then E, then F, X, Y, Z. His remote is cut down by section 14, and according to his remote is valid only up to the minority of C, and it is invalid beyond majority of C. By presuming that here A wants to transfer his property to C, but the C shall not get that property in hand unless he attains the age of 18. If he provides such, that will be valid, and even he does not provide so, that will be interpreted, that will be construed as per section 14 of that act, and this will be the effect of section 14. So friends, this is rule against perpetuity, and which specifically prohibits transferor from making property inalienable for indefinite period. So friends, if you have any doubt, please mention it in the comments. If you like this video, please subscribe my channel. So thank you friends.